Good day, Crime Talk aficionados. This is the weekly recap for September 9th through the 13th. All of the top stories located in one convenient location here in case you missed anything. Thanks for watching. We'll see you next time on Crime Talk. And remember, the Constitution matters.
Hi, lawyer.
Next, Donna Adleson. Remember her? Yeah, she's accused of conspiring with her son, Charlie, to kill a brother-in-law, her son-in-law. Anyway, her son, Charlie, was a wealthy South Florida periodontist and conspired with his ex-girlfriend, Magbuna, and coordinated with hitman, a guy by the name of Garcia, and another guy by the name of Rivera to carry out the murder. Now, Markle, the son-in-law, was gunned down while pulling into his Tallahassee driveway back in July of 2014. So Charlie, Magbuna, Garcia, and Rivera were all convicted. Now, Donna Adleson was arrested exactly 1 week after Charlie's conviction back in November of 2023. She was arrested on a jetway while trying to board a plane from Miami to Vietnam with a one-way airline ticket. Yeah, because that's normal, right? Flight, consciousness of guilt, ladies and gentlemen. Anyway, there was a motions hearing because we have pretrial issues coming up, and they frame basically what evidence is going to come in. Well, the defense presented a motion in limine regarding the testimony of a Tallahassee police officer by the name of Sergeant Christopher Corbett. Now, prosecutors want Corbett to testify about call detail records for Donna Adleson, Charlie Adleson, Wendy Adleson, Harvey Adleson, Catherine Magbuna, and Sigfredo Garcia and Luis Rivera. Now, the call detail records are files containing information about communication activities among phone calls and text messages. The information is usually derived from cell phone towers and telephone exchanges. The telephone exchanges is the physical building where the connections between the phone lines are established. Anyway, Donaldson Adelson's defense team, Daniel Rashbaum, argued that while Corbett should be allowed to be a summary witness, he should not be qualified as an expert witness. And Sergeant Corbett's report contains things like text messages and emails. And Rashbaum explained that, but the sergeant simply compiled them and cannot provide expert-level testimony, i.e. trying to interpret them, what that means, based upon my training and experience, that kind of stuff. Anyway, the judge ruled to partially allow some of the testimony in from Sergeant Corbett. As to whether Corbett can be qualified as an expert, the judge clarified that while the sergeant is capable of interpreting these records, his testimony would be demonstrative and would not be admitted as expert testimony. Now, the judge also expressed some interest in the hearing about how Sergeant Corbett put his summary together and how he ultimately formed his opinions. Now, another motion in limine presented by the defense concerned the testimony of Wendy Adleson, who changed her son's last name from Markle to Adleson soon after their father's murder. Wendy also authored a fictional book that closely resembles her real life, and the judge noted that the name change can only be used to impeach Wendy as it relates to her prior testimony. In other words, prosecutors can ask Wendy about the name change only if it relates to her previous testimony on that exact topic. The defense has wanted the prosecution to be prevented from asking such questions, such as, did you change the kids' names? The judge said it would be permitted if it was related to motive. Now, whether it can be used for impeachment purposes remains to be seen, and we'll have to wait and see how the testimony comes out. It's also not clear yet if Wendy or Donna's husband, Harvey Adleson, will face any charges related to Markle's death. Now, the judge also addressed a motion regarding the admissibility of jail phone calls between Donna and Charlie Adleson, and the state announced that as of now, they have no plans to introduce any calls featuring Charlie. The final outstanding motion addressed with the judge was Luis Rivera's gang affiliation and prior bad acts. The state argued that the naming the gang organization would present credibility issues. For example, if Donna decided to take the stand and say something like, a member of the Latin Kings threatened me, it wouldn't be necessary to call out the specific gang, as it would effectively affect her testimony either way. The judge also stated that he is still mulling the defense motion to exclude hearsay testimony of Wendy's ex-boyfriend, Jeffrey LaCase. Now, before concluding the hearing, the judge reminded Donna Adleson that if she intends to entertain a plea offer, she needs to act fast. The final pretrial hearing is set for September 12th. Now, this latest appeal could jeopardize the October start date for the Delphi murder trial. Why? Because Richard Allen's defense team has signaled that they are going to file or have filed with the Indiana Court of Appeals to overturn Special Judge Francis C. Gull's decision, barring the defense for Richard Allen from presenting its Odinism theory in court. Now, the filings by Allen's defense have moved forward with a rare interlocutory appeal challenging the decision to not let them present alternative killing theory during that trial. Now, the appeal request was filed in response to Judge Gull's handing down a decision back on September 4th, which granted most of the state's motion in limine, looking to prevent the Odinism alternative theory in the court proceedings. Now, the defense contends that the court's September 4th, 2024 order denied Richard Allen's right to present a defense in violation of his Sixth Amendment rights that he possesses under the United States Constitution, as well as the applicable provisions under the Indiana State Constitution. Now, for those who don't know or don't recall, Allen's been charged with 4 counts of murder for the alleged role in the February 2017 deaths of Abby Williams and Libby German near the Monon High Bridge back in Delphi, Indiana. Now, Allen has been in custody since his October 22 arrest, when he was arrested by the Indiana State Police. Now, this is the latest turn in the legal battle involving the defense attorneys and Judge Gull, the prosecutors as well. And a large component of the contention has centered on Allen's lawyers arguing that a group of Odinists were responsible for the killing of the girls instead of Allen. Now, the defense challenged various affidavits in a Franks hearing, saying that there were omissions that were kept from being presented to the judge, and if the judge was aware of that, they never would have granted the arrest warrants and or search warrants in the case. Needless to say, the judge has denied all of those motions like she has for everything in the defense case. Now, the cult theory of Odinism has featured a focus on various people that the defense claim are part of this group, connected to a pagan Nordic religion that has been linked to various white supremacy groups in the area. Now, the prosecutors have argued that the theory holds little water and relies nothing more on speculation, hearsay, and a lack of specific evidence being produced, tying a third-party perpetrator to the killings. This led to the prosecutors filing this motion in limine, requesting that the court prohibit the defense from including the Odinism theory in the defense. Now, the court eventually, not shockingly, sided with the prosecution, though she left open the door for the defense to present their theories of actual proof if they could actually be brought forward. You have to have a little bit more than speculation, and that's what the court put in her order. It says the case law is quite clear. The nexus must not be based on speculation, conjecture, rumors, or hearsay, but rather on admissible evidence. That's what is being appealed in the interlocutory appeal. Now, interlocutory appeals are discretionary, which means the court does not have to take them, and they can say, we'll hear it if there's an appeal and after there's a conviction in the lower court. I'd be a little surprised if the court the appellate courts took this issue up right now. They usually like to wait until the full record has been developed. Now, one thing that should be a crime and is possibly punishable by being removed from the bench, I'm just kidding, was Judge Gull's order. It was the most pathetic thing that I've seen in a long time in such a serious case. Normally, and we've seen orders from various judges, for example, in Idaho, that give very detailed explanations as to what the issue is, the law, and the analysis as how the judge came to that conclusion. Judge Gull's argument or order looked like it was basically written by, I don't know, an 8th grader. It was not very well reasoned, and that may be some basis where the court could say this record is insufficient. Let's go ahead and have a hearing on it. I don't know. Pretty unlikely. The defense, in my humble opinion, I've said this before and I'll say it again, should have saved all of their thunder for trial, and going into all this stuff, tipped off the prosecution early. Prosecution countered with a motion in limine, and the judge says you can't do it. Now understand, ladies and gentlemen, alternate theory is you have to say, to be able to go into court and accuse somebody of doing something, you have to have a little bit of proof to it. You have to be able to say, this person did it. They were at the location or near it at that time. They had kind of a motive to do so. And it's plausible that they could have done it. There's something maybe linking them to it. Like maybe the previous guy always left a card or a flower at the scene. And this one, there was a card or a flower at the scene. And this guy just happens to live 2 blocks away, and he's previously been convicted of the same thing. That would be a legitimate alternate suspect theory, not just saying, hey, a bunch of these kind of weird dudes that believe in some weird stuff that we think, little X's and O's on trees are similar enough because it's kind of weird to them. So they probably did it. Yeah, not coming in if the judge has anything to say about it. And it would have been a heck of a lot better to hold your cards close to the vest, bring it out at trial, and then make the judge shut you down in front of the jury so it looks like you're not receiving a fair trial. And then you still try to squeak it in. That's what I would have done. I'm telling you, ladies and gentlemen, how many times have I said this? This is where everyone gets wrapped around the axles, as do attorneys. They think that you're going to win on some great legal issue in criminal law. Yeah, maybe if there's a motion to suppress, sure, you get some items suppressed. Maybe you get a statement suppressed. But it still comes down to facts. Facts, facts, facts. And just like in this case, you need facts to be able to prove your theory. Doesn't matter what you think. It doesn't matter what you believe. It only matters what you can prove. And that goes for the defense as well. That's why I think some people get so upset with me, because they come up with all these theories on all these different cases, and I kind of put a kibosh to it and say, that's great, but how are you going to prove it? Well, I don't know. It's possible. Okay, it's possible that, I'm going to get hit by a huge meteor before this video is done. But is it likely? No. Is it provable? No. So just something to think about, ladies and gentlemen. Sorry to be the party pooper. Just bring it to you straight. Next, so we have an order that just came out in the Brian Kohberger matter. This is breaking news. It is a order from the Idaho Supreme Court. And because the court granted the change of venue, normally the change of venue order goes to the state Supreme Court. So the state Supreme Court decides where it goes. And in this particular case, in the matter of the change of venue order, an order granting defendants' motions for change of venue was entered in the district court, wherein it was requested that venue for trial be transferred from Latah County, 2nd Judicial District, in the case listed below, State versus Brian Kohberger. Therefore, after due consideration and good cause appearing, it is ordered that venue for all further proceedings in this case are transferred from Latah County, 2nd Judicial District, to Ada County, the 4th Judicial District. Just like we said, that's where it was going to go. It is further ordered that District Court Judge Stephen Hippler shall be assigned to this case and may not be disqualified without cause pursuant to the Idaho Code Rule 25A9C. It is further ordered that the defendant shall be transferred forthwith to the custody of the Ada County Sheriff pursuant to the Idaho Code, and it is further ordered that the District Court Clerk for Latah shall file and serve upon this order upon the parties or counsel to take any necessary action to transfer venue to the case to Ada County. There you go, ladies and gentlemen, breaking news. Ada County, and we get a new judge. Judge John C. Judge is out. New judge Stephen Hippler has been assigned to the case, and I believe he is in the 4th Judicial District. Therefore, that would be Ada County, and so they get a judge seated up there in Ada County. That's one way to solve judicial economy. Just get him a new judge. We'll bring you more as it becomes available. Next, Justin Timberlake gets his plea deal. but he had to do the walk of shame. That's right. Justin Timberlake, who had been facing the charges of driving while intoxicated, pled guilty to a reduced violation of driving while ability impaired. Now, the plea leaves Mr. Timberlake free of a criminal record, which he would have had if he was convicted of the original charge. As part of the plea deal, he agreed to pay the maximum fine of $500. I wonder if he can pay it. There was also some court costs and the surcharge of another $260, so $760. I think he can pay it. Additionally, he committed to making a public service statement about the dangers of drunk driving. Initially, the judge expressed a little dissatisfaction with the proposed statement, preferring a public service announcement. However, the judge ultimately agreed to the deal under a few conditions. Now, a major component of the plea deal by Mr. Timberlake and his attorney and the prosecutors was that after entering his plea, he would give a public statement about the dangers of drinking and driving. Now, to make that public statement, Mr. Timberlake and his attorneys walked out of the courthouse through the pedestrian bridge that connected the courthouse to the police headquarters, the same bridge that he did his perp walk in when he was arrested. Anyway, at the police headquarters, there was a little microphone and everything set up, and Mr. Timberlake addressed the media, speaking about the dangers of drunk driving. I could have told you that, but nobody ever listens to the attorney. But maybe they'll listen to Justin Timberlake. Don't drink and drive, ladies and gentlemen. It's so preventable. Don't do it. I'm telling you, don't do it. It's expensive. You could kill somebody, go to prison, affect so many lives. Just don't do it. Anyway, the court approved the minimum number of community service hours that Mr. Timberlake would have to do at the charity of his choice. I knew Mr. Timberlake was going to get the DWAI. That's just the way it is. Pretty standard. Not really special treatment, but hey, he probably got a few breaks. Let's face it. First offense, no test result because he refused, lost his license. Standard offer in just about any jurisdiction that I've ever been to would be plead guilty to DWAI first. Just don't get a second one, Mr. Timberlake. We're watching you.